Hi, and welcome to Women Who Build. I'm your host, Preet Kershaw. I'm sitting here with Andrew, my co-host, and today we're talking with Liz. So she's in the New York market. She's an attorney, and she handles a lot of construction companies out here. She is, mainly in construction. This would be good for a lot of small business if you're in business as well. She helps with a lot of different aspects. And she's also helped with the MWBE program. There was some issues going on, and a lot of people needed help. So she's definitely your go-to person for that. Liz, I'm going to let you take it from here and tell us about what you do and what you can offer, to our audience out there.
Thank you, and thanks for letting me be here today. And you hit the nail on the head. I'm a commercial litigator. I practice in New York, and my sector is construction. This primarily means working with people up and down the chain in construction, and in particular, some small businesses and diverse firms that are involved in the MWBE or DBE programs as a specialty niche area of compliance I do as well.
Awesome. I love that. So I've known you for a while now, and you were able to help me out as well. There've been a lot of changes with the MWBE program. If you're certified in New York, right, and you're going through recertification, they've been a problem. And, it's a good problem and a bad problem at the same time, because I went through it and, I got help and I was able to, get through it. What are you seeing out there with other business? And, how can you be able to help?
Well, especially the horror stories. Like what's going on now?
Yeah, so the program in the state of New York has been around for a long time.
Yes.
It's experienced some challenges and growth challenges and changes to the regulations about 5 years ago. You also hear horror stories about there being a large backlog at the state. They pretty much, the executive director who's at the helm now at ESD is the state administrative body that handles certification and compliance. He's done a really nice job to get rid of that backlog. One of the things we're seeing as a result of that was a lot of firms who had been certified previously were being denied recertification based on the changes in the rules and maybe not being necessarily lawyers in their day-to-day lives. Correct. To understand how the rules changed and what they needed to demonstrate to maintain their eligibility. And that's where we came together. And it's been a pleasure working together. And we had the ability to have a working relationship before we got involved in MWBE. But it has been, I'd say, a challenge for the state in trying to administer these new regulations in a fair and compliant way, and also be mindful of not only the constitutional challenges to the program, but the issues of fraud in the program,
Correct.
Which are real.
Yes.
And so it's actually a passion project of mine to be involved in this space, because I think the program is important, but I also think the program needs to also work and run right.
Correct.
All the way through. And
Yes.
that's sort of where we see some of the challenges.
You said that the state introduced new regulation or change in regulation to the program itself. Not only, I guess, a broad sense of the changes that it made, but did you see a good outreach from the state, or whenever anything changes, to actually inform the public of these changes and how it will affect, or even teach a person to, input their certification, recertification a certain way?
Yeah, the regulatory amendment process does have a review period and a public notice period. But I think really when the rubber hits the road, and the reality is when you have small businesses who don't have general counsel and they're worried about running their day-to-day operations, and they'd been certified, and then they went to reapply and were solicited only specific information, and things like a resume were requested, when in reality, the regulations provide that the firm and the individual must meet that burden of demonstrating eligibility. So you have to put forth that information, not just answer some questions. And I think that that's one of the biggest challenges, and something that I know that the organizations I'm involved in have echoed to the executive level of the division, is that a lot of, especially in construction, where you're applying for maybe permitting or doing things that are paperwork oriented, that are check the box type things, where the state's own process lulls people into not providing more about their credentials, more about how their ownership is bona fide. And then having to deal with that on the back end is going to create and had created, a backlog and lots of appeals. And yes, I could sit here and say as a lawyer, that's good for me, but we'd rather the program work the right way. The real firms get in, stay in, and then are used for goals on projects.
Correct.
As opposed to having to, this morning, I was in front of an administrative law judge on an appeal for a client who was denied MBE certification. It was his first time. And I had one yesterday too for somebody who had been in the program for 15 years and was denied certification at W. So I'm doing this every day. It's still happening. And one of the things that I think is important is that the state take more of a partnership role, which they have started to do, and breaking up their division and having more outreach now, sort of reactionary a little bit because it has been 5 years since that change. So I didn't, not aware of anything that was being done in advance or to help prepare maybe firms who have been longstanding certified firms for providing that much more information that's going to now be required to demonstrate eligibility. That was never the case before.
Mm-hmm. And especially with Preet being a member of multiple different certifications and have to renew every few years.
Yeah.
It's, it's seeing that in its first aspect of what do you have to do to get it right the first time and not have a massive appeal process or, go through the hoops.
Correct. But you know what I find a little bit different? So I went through all of the agency already. I did it myself. I never got help to get certification because I was doing it the right way. There was no need there that I needed help. And every agency, they actually come out and meet you. They want to see what you're doing. What are you controlling at the very beginning before they approve you? The one thing I noticed, the state did not do that. The city does that. DB program does that. SE program also does that. But just the city did not, the state did not do that. So I feel like that was a problem right there too, was that they weren't sure how these firms, whether there was legit, because there was a lot of complaints of a lot of firms that was not a woman owned, but they claimed that they were. And I get the reason why, because when we're bidding for jobs, we see what's happening. We already see that, but then who do you go to? So somewhere along the line down the pipeline, all the complaints came in. So they had to go and fix things. And I think they're probably denying everybody, because I'm hearing this from everybody. It's just getting denied. Yeah. And then
it's through my lens, it does feel like it's disproportionately denials, but there are, trust me, obviously the directory has lots of certified firms, and whether they're in properly or not is a different question. And I think that the state has put more resources towards doing interviews. I had one actually late last week on a secondary review with some of the people there. Actually, I was very happy to see some of the people who have been in the program for many years and actually know and understand construction. One of the bigger issues I'm seeing is that even if you would have been provided an opportunity to explain your background, credentials, operations of your company, it's not that necessarily the person asking the questions would understand the answer or construction. And this is it's something that could be.
With that being said, one thing that just pointed out to me was you were saying the disconnect. And the first thought I had was, while the certification process is great for so many businesses, not just construction, it's certification. It could be insurance. It could be a broker of that. It could be a dry cleaner. That is something that is a great benefit. But now the people that are actually going and certifying and going through the process from the state employee level, are they actually just people that are pencil pushers and they're given a checklist by the state and that's it? They could be just, from college or from any type of training, and there's no type of customability to say this is a construction, this is an insurance broker. You need some background or some social background to understand that the application that's coming from is coming from a construction background, to understand why they're filling it out this way. Or is it just plain black and white? You check off the boxes. If you don't check off the boxes, that's it. You get denied, which is a little bit, if that's the case, which is a little bit scary, because there's so many businesses that are just unique trades and individual, sectors that are affected.
Yeah. So the way that at least the state program works is that they have certification analysts. They're either in-house or brought in, and they're trained. They are also overseen and reviewed by people who have been in the program or administering in the program, and there's layers to that. So they're trying to build it out so that it isn't just someone inexperienced who doesn't know business or construction. But that being said, it's very hard to, especially this public-private disconnect, understand how private businesses work and what it takes to successfully operate your business. And sometimes I think to myself that some of the people who are in the position of certification analyst don't really understand that and think not correctly that if you just show up at work, your business will be successful. When in reality, I think the statistics are like 1 in 2 businesses that fail in their first year.
Correct.
And it isn't because of a lack of skill, knowledge, or ability or resources or like not being discriminated in your industry.
Correct.
So I think it's taken for granted at that level, but I'm optimistic that, look, they're looking to improve training programs. There's something called the NAICS codes, which is a system of dividing up a business into a category, a sector, and then down from there. They're supposed to be training the analysts to understand these things, but how much do you know based on having run your business?
Correct.
And then what I feel is sort of a painful point is that someone like you, who's been successfully operating your business for years and all the blood, sweat, and tears you've put into doing that, are being asked questions by somebody who does not know what running a business looks like and does not know your sector. And then you're on not even the defensive, but having to explain to somebody almost on deaf ears really what that entails. So that's part of the problem. But they do have layers of review, and I would like to be, like it's a process that always can be improved, and that's something I, take part in through my advocacy groups that I'm a part of, and kind of partnering with the agency to shed light on maybe some of these places where there could be improvement, and that is a number one area is training.
Definitely need improvement there. I remember when I got the email, I was furious. I was so upset because I was like, I work 7 days a week. So how dare you send an email like this? Like, you haven't even asked one question.
Every single client I have that's been denied, who's successfully clawing to operate their business every day, blood, sweat, and tears, 7 days a week, 24 hours a day.
Yep.
They feel like they're not being believed. And in particular, women in construction, that they are not being believed, that they are at the helm, that heaven forbid there's any man or even worse, a family member involved in the business, that they're relying on them, that they're not calling the shots. And it's an irony and an unfortunate discrimination that the program that's supposed to lift women up and minorities as well are also not going to necessarily believe women that they're running their construction firm. So it is every single client I've worked with has been denied, whether it was the first time or it was a recert, feels the same way. And they say, I cannot understand why. And that's part of the disconnect that I also feel it needs to be corrected. If you go to the state side, because I have listened to them as well, and you probably know since you're in the industry, there is fraud. There are people who should be out. They do need to do audits, but they don't need to go about it in such a way that it's throwing the baby out with the bathwater a little bit.
Do this the proper way.
As an attorney, my reputation matters with the people at the division who I work with over and over again. I would never risk my reputation to work with somebody who was trying to commit fraud or really truly wasn't willing to understand program compliance.
Correct. I agree with you. There is a lot of fraud out there. I was at an event once, and I had a lady ask me, how do you become an MWBE? So I told her it's a process. You have to, know what you want to do, and you have to then apply. So I asked her, what do you want to do? And this is for construction. So she said, I don't know. And I was like, what skills do you have? I don't know. And I was like, then I'm very sorry, you don't qualify. You have to have some type of skill. I find that very odd that I was asked that and there was no background of anything. And that's where I was like, oh my God, there is fraud in the system. Like, imagine this is just one person. So how many out there are there?
No, and it's also an interesting issue, and not to get esoteric about it, but if I had a master in business administration, an MBA, I'm a lawyer, I have a JD, and I were to go buy into a construction firm and try to get certified, and this is something I've told the ESD's director himself, I said, the division wouldn't certify me. I don't know and have the skill set to understand the work. I could get up to speed and become knowledgeable in a trade, in a type of work, but the program is it meant to keep women who are at an MBE or executive level out of leadership roles for certified firms because I didn't come up through the trades? And this is one of the industry specific issues, is the program really only supposed to be for somebody who started out as a laborer and worked their way up to foreman, super, and then PM, and then executive PM? Is that really what this is saying? It's not what the regulations say, correct, but that's what I've gleaned from seeing how they are operating the program, interpreting the regulations. And I don't necessarily know that that's necessary to be done to be compliant with the constitutional rules regarding a program that discriminates based on race or gender, which correct, is ultimately why the division abhors the fraud, is that, look, if we're not strictly interpreting the rules and they're not strictly applied, the whole program can be challenged and then we all lose it.
Exactly.
So they genuinely are believing that they're safeguarding that law and the program.
And Preet, you brought up a very interesting comment when you spoke about, interacting with that woman. And I just realized something that, all right, the program and the certification for WMBEs were brought around because, let's just say, even construction, it was dominated by, a certain field of people that just had like more control over it. It now opens up opportunity for smaller firms and for minority and women enterprises to actually have the same opportunities as everybody else. In the beginning of the program, people would actually approach other people to do a workaround, so because the firms wanted to stay with the amount of business that they had, but they did whatever caveat for a forward face just to get that work. And I think that created an atmosphere of not really realizing the benefits of a WMBE certification, because I've also seen many people say, I have to get it. And then, but why are you getting it? Like, what is the actual benefits of a WMBE? And most people would not know. They would say, okay, well, I'm just going to start a company. I'm just going to get WMBE status. Okay, well, what are you doing it for? And just like you said, they didn't know. And it's like, yeah. So the idea of getting it is a benefit, but the people who are doing it in a shady or in a ill way, it's like, what are you doing it for? Why don't do it the right way? But that's also to the education that's not being shown from the city and state. Like, if you're doing this, like, not only fill it out, and the people that are filling it out the right way or going about the certification the right way, this is, how you do it. So here's like all the training, but also too, for the people who are just doing it for a benefit, it will go nowhere unless you have the experience, unless you have, like you were saying just before, to actually be a professional and an expert in your field.
Yeah, that's something that the general contractors and the people who use certified firms, that's the challenge they face every day, is that just because somebody has a certification doesn't mean they can perform the work. They may have been off more than they can chew. They might be out of business by the time the job's over. So the program definitely has its flaws. It definitely has its challenges. I know the agencies also have mentor programs. I've heard mixed things about the mentor programs. Obviously, I don't live this firsthand. I only get to hear the horror stories through clients, but
that would be another podcast, a whole one.
Yeah. So it's
I agree.
It's something that, and you just touched upon earlier, the disparity study that the state conducts determines where there's gaps in representation in what industries. And then also why construction's a big area is that the government, the state and the governor has mandated spending to M&Ws, and a lot of spending is done to maintain and build our infrastructure in the
Correct.
greatest city and state of the country and greatest city in
Yes.
the world, right? So that's an important piece to the program and puzzle. But then if you can't get skilled, qualified firms to do the work, it's like a tree that falls in the woods with no one there to hear it. And it actually creates more of a problem. So I work with clients on both sides. I see all the angles. I see the legal side. I see the practical side. And I'd like to see the program continue to operate and successfully so, and actually boost up the people it's meant to help.
Correct. Well, I see one other area where there's a problem. So now on bids, when it comes out, it would either say 15% MWBE or 30%, or it'll be like 15M and 15W. Now, there's a lot of problem with that as well, where no one is checking in to see if these jobs are being given to women or minority-owned business. I've seen that. And, a lot of GC are submitting an addendum of they haven't found anyone. And normally it's very simple. They fill it out, they send it in, and it's done. But in the meantime, you have all these other companies that's reaching out, but they don't want to give the job. They prefer to either do it in-house or give it to a company that is not a MWBE. And I feel like that's a big red flag there. And how do we fix that? Who do you reach out to, and do they even know that these problems are happening?
Yeah, so it's interesting, the feedback you're seeing from your side of it too, because the agencies are under the same state mandate to have their capital programs meet the utilization goals. So they're administering the program the same way that a general contractor is, and then looking for firms. So the diversity folks at the agencies are supposed to be involved in the utilization plan that the general contractor submits with the bidder very shortly after the bid for their proposed contractors. But we all know in construction how it really works, where there might be a delay to the notice to proceed. Correct. Maybe somebody on the plan drops out. Maybe the pricing has changed. Circumstances have changed. So there are supposed to be quarterly submissions. It's not a one and done. The utilization plan is supposed to be submitted quarterly as to actually how much has been spent, meaning paid to certified firms that are on the plan, who's coming on, who's coming off. And it isn't as simple as just submitting a waiver or a request for a modification. The general contractor and state agency, if they're working direct to meet the goal, have to perform what's called like good faith efforts to find certified firms. And genuinely, I think a lot of public contractors, even certified firms themselves, don't know how to go about that process, don't understand what that means. I do a lot of training on this as well, upstream, not obviously to your folks, but to GC clients about how to go about good faith efforts, even just what the MWBE directory is online, and then how to go about getting the business. Because when you're in business, you're working on relationships.
Correct.
And you're getting invitations to bid based on work maybe you've done or a recommendation you came through someone else that you know in the world. The program is a little bit strange in that regard because it expects the general contractor to literally like use a phone book and cold call. And it's very hard to expect business to work that way. So it's another little disconnect in the program. They're like, no, we want you to literally just pick up the phone, send a bid package, not really maybe knowing who or what or how. And then what winds up happening is that bigger GC firms will then institute their own compliance departments because they're then on the hook for making sure not only have we sought out certified firms, but then we want them to succeed. So let's make sure they're actually able to perform the work, capable of getting to the finish line and things like that. But that doesn't always happen. There's so many public jobs. There's so many, every single one has a goal and obligation. So it is always amazing to me how many times I feel like I can go out, network, and provide the same basic information about MWBE 101. And at some point, I swear I'll get to 102, but it really is, the basics need to be learned by people in the space, both upstream and downstream.
That's a good topic, or just good bullet point to actually say, because actually the education even upstream to the GC, if you are now dealing with the WNB firm, there's certain other things that, again, with knowledge and education, that they should be aware of. For example, just even getting them on the job and filling that quota. Also, too, there's certain laws in place that say, like, you cannot hold their retainage forever, because you did not get your retainage. And sometimes, the GC themselves don't have that knowledge or education. And these are the benefits of becoming a MWBE. And now you're out of compliance in a couple different ways, from the start to the finish. And they don't know. They're like, oh, I didn't know that the laws changed a couple of years ago. I didn't know that there was prompt payment, procedures and laws. And sometimes, they just think, hey, let's ignore it. And now you're being put as a WMB firm that you've done your job. You've done great work. Okay, now I still need to get back. I'm told that these are the benefits of it, and I'm not getting it. So now, do I risk a relationship with the GC that I just did a whole job with? Does that sour it because they're not actually going with the compliance? And it's something that firms deal with every day. And it's a big issue across the board. And then it just turns into a bad situation.
Yeah, I think public contracting is hard in the first instance in terms of timeliness of payment, ability to have cash flow for literally to pay labor on a daily basis, and then to ask a firm to be small and disadvantaged to also participate, and then also run with the big dogs in terms of floating payment from municipal entities for eons, whether that's base contractor or extras or otherwise. Yeah, it's that would be probably something a general contractor who has to use certified firms would lament about, saying, look, people on my plan can't withstand this pay cycle or this change order review cycle. It's just untenuous. And then firms go out of business and they say, what do you want us to do here? How is this program benefiting this company when you're doing the public contracting? So that feedback is something that I know I'm part of other trade organizations, and especially in the trade level group of people, that's a big, big issue. And one of the strategies as counsel that I employ is always to give clients the advice to reach out to the diversity folks on the job. They're supposed to be able to intervene in this way because they're supposed to understand the restraints of the program, such that that the firm may not be necessarily able to withstand a lack of cash flow for the period of time that is just like another day for the agency. So it's definitely a challenge how the program works.
Yeah, I think the program does need a little help there too. Even complaints, I feel like it's taking longer to be response to, maybe weeks even. We've went through some things too with contacting when we needed help for payments, and we didn't really get much of a response. It was very surprising. It's like, does anybody work there? There was no phone call answered. There was no email answered either. It was very odd. Like, what is really going on?
Yeah, staffing turnover in public contracting is a big deal. I had a client tell me yesterday that they're on their fourth resident engineer for the job, and it's only been a year. So, yeah, a lot of turnover is an issue, and staffing is an issue. It always will be. So having somebody knowledgeable on how to handle and get ahead of disputes and manage your business and having a team of service professionals is also super important, because for better or for worse, this is what we deal with every day is the worst case scenarios, the problems, the issues, and helping advocate for clients.
Yeah. So let's talk about contract. Now, contract is very complicated. You have to have a contract, but there's a lot of legal terms in there that a lot of business don't realize that they need an attorney to review before signing it, because you could literally be signing things that, liquidated damages, for example, it could be so high and you don't even realize it, and then you're caught in a job. That's just one example, but there's so many on there as well. What have you seen out there?
The horror stories.
Oh, yeah. I mean, the worst you can sign is something that personally guarantees you. Yep. And we always ask clients to have their thoroughly review your contracts before you sign them, or even if you've been forced to sign them, have them reviewed thoroughly so that you can understand what the rules of the road are. But obviously, if you can get ahead of it, and if you have any bargaining or negotiating power to work with counsel to understand and change some of the terms that might be onerous and otherwise. As a subcontractor in particular, liquidated damages are difficult to swallow, in particular if the job involves other trades and you may not be responsible, but then if you get handed down LDs, then you're on the defensive. So I always like to tell clients, or at least when I'm negotiating, to get rid of LDs that are trying to be imposed on them, that, look, GC, and I do work for GCs too, so it is true. Covered through indemnity if, in fact, I totally mess this up. So let's not agree to liquidated damages. Let's just keep the indemnity. And if there's a problem that you know that I caused, you will be able to come after me for it. Now, look, sometimes that works, sometimes it doesn't. There are notorious players in the industry who have 50-page terms and conditions and won't change a word. And then a lot of other times, though, they're a little bit more fair. And what's important that trades know is that they should attempt to negotiate so that the climate isn't so severe and that more GCs aren't just saying take it or leave it.
Correct. And there's a lot of things in contracts too that, that can hamper someone rather than any good. Even insurance, just to make sure that your insurance is, your limits. It's correct. That's on there before you sign it. And definitely personal guarantee. That's a big one.
Have you seen it?
Yes.
You have? I've only heard of it.
Oh my God. I would never
warn against it. But
yes.
I haven't actually had a client come to me with something that included a personal guarantee, but I know they exist.
They do. They do. They do put them in there. You'd find them all the way towards the end, most likely.
Yeah, that's true.
But it is scary to sign something and you're not realizing what you're signing. Guaranteeing your work, I agree with, guaranteeing your labor because you're providing labor. I can understand, but not anything beyond that. No. And on the other side,
even with a warranty or guaranteeing your work, it's important to be particular as to when that is triggered and how, a trade that could be a lead trade doesn't get stuck with a year from final completion of all work on the job because their work may have been in place and in use for years. So it does depend obviously on what your specific trade is and what maybe a nuance could be for you. But that's an important thing that I am regularly changing for clients and contracts. And it's not necessarily that it's the GC's trying to be nefarious about it. They're just trying to blanketly cover themselves. But that's where it's important to read it. It's important to know what it says in terms of payment terms, in terms of change orders, in terms of indemnity, insurance, guarantees, things like that.
And what do you call it? You brought up a good singular topic, but it could be, shown as a whole on any type of thing that you give. Warranty is actually something that I've dealt with a lot. And most people would just say, I give warranty of my work for the next year, instead of actually going to detail and saying that the craftsmanship and the installation of this material is my warranty. It does not include normal wear and tear or maintenance. Let's just say that the facility does not follow the proper maintenance of that product or that installation, that if you do it in detail, any of these things that go on other parties actually affecting your warranty to be as detailed as possible, because they could clean it with a acid cleaner and totally ruin it. But if you have a blanket warranty, you're on the hook. But if you say the materials are under the manufacturer's warranty and my craftsmanship based on the day that I installed it is a warranty for a year, but it does exclude if other parties are tampering with my work, then these are little things to watch out for that I've seen.
Yeah, really, it's a tell for any term that you're looking to negotiate. The more detail and more explanation about the mechanics of how it's going to work, the better. And smart people like yourself understand those distinctions, the more you can make in your favor in terms of detailing how it's supposed to work, not just a simple warranty. So I have a client who does the local 11 work, and it's hard to get up. You'd have to reinstall scaffolding. And so we make it in his contract that the investigation process has to be paid for by the owner, or it's not a given that they're going to bear the cost to participate in the warranty claim process. And then, so that's a way that, just that particular trade has identified a pressure point and used specific contract language to mitigate their costs, risk, and otherwise probably having learned their lesson from it not going so well in the past. And look, it's a balance. You want to work with your clients. You want to be a team player. One thing that I always am weary of is that when you're giving pricing, you have bid exclusions, you're bidding drawings, and then you get the job based on that information, your quote, then you're given the owner's T's and C's such at a later time, or it's really not fair. You may already be on the job and you may be feeling compelled to sign it, to get paid, etc. And that's just something that I think takes a partnership of transparency between both the GC and a trade, both people, to get in front of those issues. Like, why would you want to sign a contract that has LDs, but you've already started and they're holding your check, right? And so it's both parties to make sure the proper procedures are followed before the work starts, before everyone has their sunken costs, so that you don't lose any leverage you may have had to negotiate.
Correct. It's true. And then some bonding company, if you needed a bond, they have issues with that as well. They don't want a high number. So then it would come back as a review now. Okay, what can we do here?
Yeah, so how are you often seeing that you're asked to provide subcontractor bonding?
On some jobs. On some jobs, yes. And
or
then
high insurance.
Yes. And they would come back and be like, okay, the LDs have to be this number. It cannot be above that number. And then
right. Well, because there's a limit to the exposure that there's only so much damage one trade that's part of a bigger piece of a puzzle can do to a schedule, to the cost and things like that. So that's fair. Yeah, look, that's one, in one way your surety might be looking out for you. I mean, in another way, I'd prefer it if the jobs were not, or you weren't required to provide bonding, or if you were, that you knew that going into it, so that it wasn't anytime. That's another provision I often strike or try to change, is that, and I think it's worded this way in some AAAs, that a GC can ask for bonding mid-job. No. Wow. That changes the game in terms of the cost. And even if they're going to pay for the premium in terms of your bonding capacity and what you expect and how you run the job, when you have so much more to risk.
Correct. And you just, ask questions along the way. It's not because it's written, that means it cannot be changed. It can always be changed.
And it actually very much matters because, and for people who are watching this and don't know how much a bond could cost, or maybe that they're getting into construction, that maybe some of the future jobs will need a bond. If your project is a $500,000 project, you are paying 3 to 4% of the value as a premium to the bond. So we're talking about how you were saying cost midstream that you did not know about. Mm-hmm. I mean, we're talking about something could be $20,000. For a bond premium, that is a huge thing that was not estimated in the budget. Yeah. So,
and what's your alternative? You don't get it because you were asked, but your contract says you have to, and then you're in default.
Yeah.
And then you either get tossed from the job, you lose your ability to earn a profit.
Correct.
And you don't want to be in that position. No. So I think it would be penny wise, pound foolish to not invest resources into contract review up front.
Definitely. That's why you need an attorney. A lot of small businesses don't feel like they need an attorney. And, when in doubt, you need an attorney. Being in business and knowing your day-to-day task, that's a bit on the easier side. But when it comes to legal things and keeping your company in compliance, you need legal advice. You need someone there who know everything that's happening and how you need to keep your business in compliance. And, being in contract with big jobs, every business start out small and then they grow. So you need a good, attorney that's there to look out for you and making sure that all this is good. And you don't have to be the middleman. The attorney is handling everything, So it works out better that way, that the attorney is dealing with these GCs and they're seeing that it's coming from attorney. We're going to negotiate. So we're going to go a little back and forth. So it does work out. What else do you see out there with small business that they need help with, or, maybe they're afraid to get an attorney and they're not doing things that they should be doing?
Yeah, sometimes when I work with smaller firms, the way I describe it, legal services, especially when someone's coming to me without a dispute, like if you're being sued or you need to sue, that's a different story. Yeah. But if you're looking to just learn a little bit about maybe the contract process, or you have a question about labor compliance, or
Yep.
that you engage somebody who you would otherwise have if you were big enough as an in-house general counsel, but that they're outside. So in the finance space, they call it a fractional CFO or something like that. This is similar in the sense that attorneys like myself, and I have colleagues, and it's, we'll do day-to-day counsel and advice where a client can put gas in the tank, so to speak, and call when there's an issue. And I think a big thing that I wish more small businesses knew is how to use your journey properly and call before you're in default, or call before there's a problem or some deadline is missed. Because I'm wearing a cape right now, but I don't really wear a cape in my professional life. And, there's only so much that can be done when it's delayed getting your attorney involved. So it's an investment that I think pays it for itself, especially when you have a good client who wants to learn, who wants to build their knowledge base, work smarter, not harder, and not repeat mistakes.
Exactly.
But everybody has to learn.
Well, most people think, and especially when they're starting out, that the attorney, they most of the time think of it as a financial offset instead of an education and knowledge benefit. And one thing that just came to mind is actually advising new businesses that are getting certified, especially when they're getting certified by a specific municipality, is that great, you just got into that program. Did you realize what type of program that you got into? Did you read the master contract, the general conditions, or anything? Perfect example is I had a former client who fantastic, genuine, really great, caliber person. And they were working for a municipality. We'll keep it silent, not to create drama. But reading the general conditions of that agency, they did not know as a GC, and they're super excited about getting those jobs, that if an NOD or a change order would come through, you cannot deny it. You have to accept every single one of them. And in this case, in particular to my former client, it was double the value of the contract. And while excitement happened when those NODs would come along, he did not know that it's going to be several years until he gets that money. And with that, it almost, we're talking about a hairline away from bankruptcy. The only reason, because he was lean and he knew how to keep everything very lean, but he did not know. So he was taking on jobs, no problem. Yes, sure, everything is great, but actually didn't understand the program's rules. And so he was stuck and he had to do it, or else leave, go out of business. Wow. And that's insane, because I think he would have bid it on the jobs differently. He would have maybe been a sub instead of the GC on this particular job, or maybe took a GC role in a project that was dedicated, that he knew was only going to be the scope, not could turn into a bigger scope.
Yeah, but you truly never know. And that's why it's good to partner and know which agencies you should be partnering with, who you can wait to proceed on change order work until registration. Some agencies require that, some don't require it, some mandate it, right? So it just depends. And it's a hard lesson to learn. And even if, it was double the value, it's still within the contract scope and they have to perform. Or if it's bonded, you will have your surety called in and you're defaulted and you're personally liable with your surety. So it's damned if you do, damned if you don't. It's something that unfortunately a lot of agencies, they're aware of it on a project level sense, but they don't understand from the business side. That's this person's livelihood. They employ people who may or may not be able to continue to be paid. Those are their families. So it really does, it matters. And look, having a good advocate and knowing your rights is a start, not just chasing any work that comes your way, being choosy. And those are all part of the public contracting puzzle.
Yeah. Have you seen anything from, especially with clients and cases, obviously not into detail, client privilege, but you're seeing a municipality actually act as a bad actor, or a CM that's obviously contracted with the city, that it's towed the line of inappropriate. Have you seen any cases like that come about?
I have heard of kickbacks, certain agencies, there are indictments, it's public information. Certain agencies are notoriously bad, some are better. I've had clients investigated and you don't know if they're necessarily a target by an AG or OIG. Yeah, no, it's all out there. But I'd say what happens more often is that it's really a human personal, like personality issue. Sometimes if there's a rough job going, it's because somebody's like either said words or thrown fists or, so, I see that more often where there's like a personality difference between the agency or the construction manager and the contractor. And it's sort of like that line, like they're the other guys. And, and then look, on a legal level, it's not nefarious, but their contracts are built to favor them. Their adhesion, right? You bid the job. The contract is not negotiable if you're a GC, if you're directly dealing with the owner. They'll tell you, oh, well, we have a notice provision or we have waiver language and you've fallen into our trap and it's in black and white. And if you don't know the contract the way we know it, then you're out of the box. And it's not necessarily fraud. It's actually enforceable, but they're waiting for people to sleep on their rights or for their rights to have lapsed or passed. And then you are in zero negotiating power and leverage to get paid or do whatever it is to make right the situation. So I see that more often. I like to give people the benefit of the doubt, and that I think the personalities thing comes up a lot more than anyone necessarily saying, I'm out to get a contractor. That and levels of incompetence just seem to always, asking for the same pieces of information over and over and over again. I have a client who is working near high energy voltage in the city. So there are certain regulations, and the agency is not willing to recognize that they need a certain level of clearance and a shutdown. And it's been about 4 or 5 months arguing back and forth whether or not the work can proceed safely. And the contractor is pushing to say this cannot be done safely in this way without a shutdown. And the agencies, either they're professionals or internally, it's been a very big hurdle to recognize that. And that's a safety issue. Wow. Nobody's trying to kill anybody, but it's that, my client's telling me, why am I telling the agency what their own rules are? And it's a left hand not talking to a right hand, or, somebody wanting to push a job, meet the deadline, whatever it is. And I see that a lot. I don't always think it's intentional.
And that's something that if being pushed to do things faster and have that safety concern, God forbid something happens.
Correct.
The agency itself or anything like that is not not liable at all. It's the contractor's insurance and sometimes livelihood. I mean, that is, especially with a lot of the things that we do on the job site and whatnot, it is very dangerous.
Yeah, it is dangerous.
And that's one thing about Preet that is in her vision statement, mission statement, every statement that she has is safety. And
safety is number one. That's it.
Yeah.
Everybody needs to go home to their family. If you have to take an extra 5 minutes just to making sure that your setup is fine, that's what you need to do. You going home to your family is more important than, just rushing through the job. We're not here just to rush through and then things goes wrong. Your family needs you at home. We need a safe job site. And that's one thing that, I see a lot of company out there, safety first, they're having these meetings every morning and they're preaching the same things. And those same guys are fully trained and equipped. And yet something goes wrong, like, what happened?
Again, people are not knowledgeable of the procedures. So they say, oh, I have to do it. Oh, well, we have to do this or else we're going to get in trouble. How are you relatively going to get in trouble when, like you said, this was the agency's own procedure of safety?
Yeah.
So,
well, they want to meet deadlines, and then it's incumbent on the contractor back to contracting to understand the process for time extensions and change orders and differing site conditions, whatever it is that you need to notify them about formally and elevate that process. Because I think a lot of construction also happens in real time on the site, and it's not necessarily always documented. It's not always necessarily reduced to writing. And that's a big part of public contracting is record keeping. Mm-hmm. The contract requires it. And it's like, if that didn't happen in writing, it never happened at all. And it doesn't matter. There's 10 people on the job who saw it and agreed that there should be a shutdown. It has to be formalized. And that's where I think people feel like, oh, well, lawyers, are always saying get it in writing, but it's true.
Yes.
And it's required if you're doing public contracting to do those things.
I think after something happens, then that contractor learns that I should have had it in writing.
But that's such a bad
it's
way.
the wrong way for it to happen. But I've seen it so many times that it's like precaution is better than when something happens. Then you're looking to make some changes. So it's really better to have things in place and try them out and making sure your employees are following. Because then when something goes wrong, you're there trying to figure out, oh my God, I have 10 job sites. How am I going to do this? Like, how do I make them do these little things that it should have been done from day one?
And with that, most of the time, before something bad happens, we're always by nature good. So in a friendly nature, we'll say, okay, no problem. That person actually cares about our company. Then something goes wrong and everybody realizes nobody cares about me. They will blame me for everything. And that's why you should have the attitude from the beginning. Hey, listen, every single conversation, if it was verbal, as per our conversation we just had, we agreed to move forward on this due to safety officers being on the job site and making sure that this electrical situation is being monitored and done in the safest way. Great. You did it verbally. So now you're putting it in writing to say that we agreed upon. There's no animosity. There's no, misconception of what just was spoken about. And if the person comes back and says, no, that's not what we just discussed, their intentions right there. That it was just talk to get you to do something and you just protected yourself right there. So
yeah, I have this issue come up a lot too it's less with safety because hopefully you think that people are on the same page there, but
yes,
with extras, with changes, with differing site conditions, the agency doesn't want the contractor to necessarily formalize their claim or formalize the issue because they can deal with it how they want to deal with it if it's not in writing. And it's a rock and a hard place. I've had clients come to me saying, no, the project personnel said, please don't put this in writing. And I said, well, I'm your lawyer. I'm going to tell you to put it in writing. And it's ultimately the business decision that the owners make on how to handle that. So I commend you for doing that because I get to sit here and tell you what you should do. Yes. And then you actually have to make those decisions on how to handle the situation in the best interest of you, your company. And like I said, if it's safety, it's kind of like a no-brainer, but when it's not, it's
What's your take on New York insurance?
Oh, the cost of insurance in New York? Yeah. It's prohibitive. Yeah. It's difficult. It's the trial lawyers. It's
so much.
The scaffold law. It's a lot. It's a labyrinth of New York specific complexity. And I don't know if you feel that OSIP makes it better or worse. There's definitely, pros and cons to that as well. But yeah, I always tell my clients when I see insurance writers, I don't know what you have. Yeah. I'm not your broker. Review this with your broker. Yeah. I did not look at this because ultimately, and how you bid your jobs also, you have to look into that. And I know how you're getting priced on change orders will also be important because a lot of times I hear clients say, well, this change order markup doesn't even cover my cost of insurance. No. And that's the number one thing that happens.
And some GC are very surprised when you actually give them your cost of insurance. I've been asked this before too. Oh, can I see, some more information? Like, this seems very high. And it's like, you're a huge GC. They should not even surprise you. Yeah. Because I'm sure you're paying 100 times more than this. So this should not even surprise you. I do like OSIP work. Actually, I do. We do a lot of those. And it's good. Just with general insurance is crazy.
So, Liz, let me tell you, I've learned so much today about what goes on. We've gone through some of the trials firsthand here and there in our careers, but I learned so much. And with this episode, there'll definitely be a recap on our podcast website. So that way, anybody who's watching right now could just analyze it from time to time and see like little tidbits of advice. So, fantastic.
Thank you. Yeah.
Pleasure.
Yeah. Thank you for coming on, Liz. This was amazing and great information for everyone out there. Small business, someone who wants to start in construction, woman out there, especially a woman out there. So before we go, I have to ask you, what is your beauty secret? What do you use on your skin? As you know, we're always on the go, right? And you're a mom also.
Yes.
So we do have our challenges.
My grandma Obi, rest in peace, told me when I was very young not to use any face makeup, and I don't.
Really?
That's fantastic.
I think she knew back then that it was probably full of poison.
Yes, of course.
And now we're so more acutely aware of that. So like I try to teach my daughter, who's only 5,
Yep.
clean beauty. If you want beauty,
That's it.
because she's going to want to play with makeup.
Yes.
I'm like, clean beauty. So that's my secret, as little as
I
possible.
love it. Fantastic. I love it. What about face serums or creams, night creams, anything like that? What do you like?
I'm like into the European mode here, where I
Okay.
believe in facial massage.
Yeah.
Where I think it's like, look, your face is a muscle. It needs
Yes,
to wake up
100%.
with you, and it's good to
fantastic.
get a facial once in a while.
I love it. Clean beauty. I mean, that's the way we want to go today. Definitely keep clean beauty. Thank you. Yeah. Thank you all for joining us today. Liz's information will be at the bottom of this podcast. You can reach out to her for any help. She'd be more than happy to help anyone out there. And if you'd like to join our podcast, please do send us an email, and we'd definitely love to have you on. Thank you, everyone.